You ready, Joe?
Ready.
All right. Well, good afternoon, everyone. My name is Sebastian Sanchez. I'm a staff attorney with the Tzedek Legal Services Employment Rights Project. Tzedek is a legal services organization that is dedicated to providing free legal assistance to low-income individuals that reside in Los Angeles. Our attorneys help community members with a variety of legal issues, ranging from helping folks avoid homelessness or representing them in their eviction cases to helping undocumented immigrant children become legal permanent residents, and including representing workers in a variety of employment claims, be it wage theft, be it discrimination or harassment, and now in the current context that we exist, providing a lot of assistance to workers figuring out how to get income replacement and how to deal with the current situation of having lost their work due to COVID-19. Today, I am joined by Joe Phillipson. Joe is a summer clerk that will be working with us this summer. He's a student at UCLA Law School. And Joe, take it from there.
Thanks, Sebastian. As Sebastian mentioned, since the first week in April, Tzedek's Employment Rights Project has run a weekly clinic that takes calls from working people throughout LA County. And during these clinics, an Employment Rights Project staff attorney presents on the common questions workers are asking at their clinic, provides updates on the current status of unemployment insurance, and answers your questions. I
wanted to mention as well, one of the other things that you can find on Tzedek's website, along with our information about our current clinic, which you can contact, we run it every week, is a guide that we've created for workers' rights during COVID-19. We regularly update it. This one says last revised April 8th, but we made a revision just last week. So we're regularly updating based on the information that is coming out, the different laws that are being passed. So we encourage you to check out our website to get information about this guide and access this guide. This is something we've done with our partners at Legal Aid at Work and Centro Legal de la Raza, two organizations based out of the Bay Area. So we really try to make sure that this thing addresses all the issues that may be confronting workers in California during COVID-19. Go ahead, Joe.
Thanks, Sebastian. Yes. And as Sebastian mentioned, obviously COVID-19 has devastated California's economy. So as of April, our state's unemployment rate stands at 15.5%. There are some signs that Californians are returning to work. Our weekly unemployment claims have dropped from more than 1 million during the week of March 28th to just over 246,000 last week. So in the first part of this webinar, we'll discuss questions facing workers as California begins to reopen. And in the second part, we'll address some of the most common questions we've heard from working people who access the resources we offer in our clinic.
So Joe, do you...
I think we just, if we just want to advance the slide. I think, great. So firstly, we just want to talk about, and as California reopens, many workers face a daily choice between their health and continued employment. So Sebastian, if I'm offered the opportunity to return to work, but I don't think it's safe, maybe I'm not sure that my employer has the right personal protective equipment, or PPE. Maybe I'm not sure that there's social distancing being practiced. Maybe I work someplace where the quarters are just too cramped to maintain a social distance. What can I do if I find myself in that situation?
Right. Thanks, Joe. So, there is no obligation to ever take a job. Under, the United States, we have an at-will employment context, which means you have a choice whether or not you want to accept the job. The impact is on whether you or not you're going to be eligible to continue to receive unemployment insurance benefits, or UI. For unemployment insurance, as people that are receiving it know, you have to certify every week whether or not you've refused a job. And you're obligated to be eligible for unemployment. You have to accept something that is suitable employment. For purposes of health and safety, what suitable means is analyzing the degree of risk that exists to an individual's health and safety. In order to do that, the first thing that people should do is analyze whether or not there has been the governor's or the state of California's resilience roadmap has authorized your workplace to open. The state is releasing pretty detailed guidance for both specific industries and counties with regards to who can be open, what type of businesses can be open, and what can be offered. If an employer is not authorized to open under this roadmap, that's a pretty good indicator that there's likely some sort of risk to your health and safety. And you could point this out to EDD as something, it's not suitable employment because it's not even allowed to be functioning at the moment. The next thing to keep in mind is what you'll want to think about if you think that your health or safety is at risk, is that under the Families First Coronavirus Response Act, there is leave that is available, but you actually have to be working. So in these scenarios, to be eligible for this leave, you would have to actually either be voluntarily taking time off or be currently employed. That means that if you're offered a chance to return to work, you should return to work and analyze whether or not the job is safe. If it is not safe, then there is this emergency paid sick leave, but it's available really only for those people that are diagnosed with COVID-19, are caring for someone that's quarantined, or if they're subject or if their family member is subject to a government or doctor's order. So if, for example, you have a family member that is particularly susceptible or at high risk and their doctor has written a letter saying that, anyone that is taking care of that individual should not expose themselves, that could form the basis for you to request leave under this law. If you do get this leave, you'll be eligible to receive up to 2 weeks or no more than 80 hours over those 2 weeks at full pay if you're caring for yourself, and at 2/3 pay if you're caring for that family member. Note that this only applies to those employers at the federal level that have less than 500 employees. And those employers that have less than 50 employees may be able to request a waiver from this law. So it's not a guarantee. In California, the governor passed a law applying this to any food services worker that works for anyone with over 500 employees. So most supermarket workers, restaurant workers would be able to acquire this. It's also worth noting that in the city of LA, this was also passed to apply, an ordinance was passed to apply this similar type of law to all employers with more than 500 employees. Finally, there are protections under California's laws. Particularly, there's California Labor Code Section 6311. And if you find yourself, if you believe that there is a reasonable risk to your health and safety, that there is a hazard to your health and safety, a worker can refuse to perform that work as long as a reasonable person would think that their health and safety would be in danger. There is a fairly high threshold. You do have to establish that the risk to your health is pretty severe. It's not just, I may I may injure myself in a small way, but there may be a severe risk of health of damage to my health, which I think under COVID-19, because of the heavy risk that exposure to this could cause, if there is a reasonable risk that you will be infected, not just a generalized concern of being exposed, then I would encourage workers to do a few things. First, offer to do the work only if the employer makes it safe for you to do so. Ask if you can do the work from home. If that's not possible, request that personal protective equipment, that PPE, that would make it more safe for you to be at the workplace. And if your employer refuses to do that, ask if there is other work that you can do. If at that point your employer continues to deny you any opportunity to make this a situation where you feel that you are safer, then you should be able to report to EDD, hey, I don't think that this work was safe.
Thanks, Sebastian. That's really helpful. I want to just follow up because even if the workplace is safe and I do want to return to work, obviously schools right now are closed, and it's not really clear when they'll reopen, and a lot of childcare options are closed as well, besides schools, and summer camps may not open. So if my kids are home, and I'm the only person who can care for them, and I can't go to work as a result, is there any way that I can get some kind of benefits, or are there any ways I can get some help, while I have to stay home and care for my children?
Well, there are a few things. So under California law, there are two things that I want to highlight. The first being that the Family School Partnership Act provides you up to 40 hours per year that you can take off and have your job continue to be protected. So if your child's school is closed, if you have to attend a parent-teacher conference, for a variety of reasons, if there's anything impacting your child's schooling that you need to take time off, you have up to 40 hours per year that are protected. Additionally, EDD, the Employment Development Department, which administers unemployment here in California, has been fairly clear that if a parent is unable to get any other childcare, they can be eligible for unemployment insurance. This requires you to actually demonstrate at some point, right? There will be an investigation that there are no alternative options available. So if it is a family of two parents, it would be useful to show that one of the parents has a job that does not allow them to take any time off, or if it's just a single parent, to show there are no daycares, there are no child cares. It's fairly easy to establish now. These are not places that are being opened up en masse, so you can definitely request unemployment insurance. And then as well, under federal law, if you are, as I noted earlier, under that same Families First Coronavirus Response Act, that same emergency paid sick leave that is available to people that are diagnosed or ordered to self-quarantine, that is also available for people whose children are unable to attend school because they've been closed. And then again, for the first 2 weeks, that's 80 hours at 2/3 pay. But then there's an additional 10 weeks at 2/3 pay that is available for parents when their schools are closed. Again, I want to be clear, you have to actually be employed. So it's not enough that you were already furloughed and now you're being invited to return to work. But if you are returned to work and the school's there is no child care available to you. So you have to be currently employed. It's important to keep that in mind.
Got it. Thank you. And so that, I think, raises another question, which is, if I have to turn a job down and I'm receiving unemployment benefits, how do I inform the Employment Development Department at EDD? How do I let them know that I had to do that?
Right. Thanks, Joe. So as folks who are receiving unemployment know, there is a requirement to certify each week. And question number 4 asks, did you refuse any work? And here you would have to mark yes, not no. You have to be honest with EDD. One of the things that you absolutely want to avoid is finding yourself being disqualified from unemployment insurance for having intentionally misrepresented your situation. And you should be very confident that your employer will absolutely inform EDD if they have laid you off or furloughed you. They will report to EDD that they have made an offer of reemployment for you, because ultimately it is a cost to them to have to pay unemployment benefits. If they exhaust their reserve, their unemployment insurance will go up. So they have an incentive to make sure they report job offers to employers. So it is critical that you report it. Now, if you believe that you have good cause, if you think that it was unsafe, if you don't have childcare, EDD will contact you and they will interview you about the situation or the circumstances that led you to refuse that work. And you should be prepared with proper documentation. So, for example, if you had refused the job because you felt that it was unsafe, you should inform your employer of the reasons that it's unsafe via email, at worst case scenario via text. If you have an in-person conversation, write down a note, document it, write down the day, the time, what you said to your employer, what your employer's response was. This is all really useful to be able to show EDD that you really thought through the reasons of why you could not accept that work.
Got it. And so what if I'm offered a job, or even if I'm offered to return to work, and I'm offered a job that pays less than what I used to earn?
That's a good question, Joe, and that's something that's certainly coming up frequently for workers. Again, I'm going to talk again about suitable employment. Just as we talked about, if you refuse a job because you felt it was unsafe, it is really important to keep in mind that to be eligible for UI, you have to accept that suitable employment. The only way that you would be able to establish that a job that pays you less is not suitable is if you can show that there was good cause to reject it. Now, to show that there is good cause, you want to show that the amount that you're being paid or the amount that you're being offered is less than what others that are doing the same type of work in a substantially similar circumstance are being paid in your locality. If the hours that you're being offered are less, if the working conditions are substantially less favorable, all of these things are ways for you to show that, you know what, I'm being offered to do a construction job at $20 an hour, but right down the street at another construction site, they're paying people $35 an hour. And I am not going to accept this job. I have good cause not to accept it because it is much less than what other people are getting paid. It is not enough for you to say, you know what, I used to get paid a lot more in the past, and now I'm not getting that type of money, so I'm not going to take this job offer. Unfortunately, our UI system penalizes that type of situation. So you have to show actually that it is substantially less favorable than similar work in your locality.
Got it. Thanks, Sebastian. And to that point, even if it's not quite less than I used to earn, in terms of an hourly wage, what if I'm offered a reduced schedule?
Sure. If you're offered a reduced schedule, similarly, well, the first thing is you're eligible for partial unemployment. So if you are working and you're getting, let's say, half your schedule, you're going to have to do some quick math. If you're paid more than, say, 4/3 your weekly benefit, then you will stop receiving unemployment. If you are receiving a pandemic unemployment assistance and you earn more than $600, then you won't get PUA. But if you just refuse a job simply because it's less hours than normal, again, that could come back to cause a disqualification for UI, because EDD will inform you you're eligible for that partial unemployment.
Great. Okay, that makes a lot of sense. Before we move further, I just want to ask Sebastian, this all sounds kind of complicated, and if I had some questions about any of this, if I found myself in any of these situations, could I get help with some of these questions by calling the Employment Rights Project Clinic at Tzedek?
Absolutely. I encourage anyone that has any questions, not just about this, but anything related to their job, to contact their clinic. And again, I'll just run back really quickly to our clinic information. You can call us at any time, 323-939-0506, extension 415. Leave a voicemail with your name, your phone number, brief description of the problem you're facing, and one of our team secretaries will get in contact with you, gather some basic information, and schedule you for a clinic. We are running our clinic now at least once a week. Sometimes we run it twice or even 3 times a week, depending on the number of calls that we're receiving. So you are welcome to contact us. We're not doing any in-person appointments, but we will do a presentation. We will do an intake with you by phone. At this time, if there are any questions that people have, I'm happy to answer any questions before we continue with the presentation. I'm just going to give a quick moment for people to ask any questions in the live comments, and if I don't see any, Joe, we can continue moving forward with the presentation.
Great.
Okay, so let's move on here, Joe. So the second part of this presentation, Joe, we're going to focus, rather than focusing on returning, we'll talk a bit more about the current situation, some of the more common questions we're seeing at our clinic, and some of the more frequent issues that people are facing under COVID-19. Go ahead, Joe.
Thanks. Yeah. So if I've been unemployed throughout the crisis, and I find myself still unemployed, can you tell me how long I can expect to continue to receive unemployment benefits?
Absolutely. So under California law, UI benefits are provided for at least 26 weeks. That's half the year. Under the federal law, there is something now called Pandemic Emergency Unemployment Compensation, PEUC. That extends benefits for 13 weeks. Now, that system has not officially launched, but beginning tomorrow, May 27th, if your benefit year, so that is calculated by determining the date that you filed to the date that it ends, that 1 year after you filed. If your benefit year started on or after June 2nd, 2019, and you've exhausted all of your unemployment insurance benefits, EDD will automatically start signing you up for this 13-week extension starting next week. If your benefit year started before June 2nd, 2019, and you've exhausted your 26 weeks of benefits, and starting in July, EDD will send you a notice informing you as to whether or not you will be eligible for this 13-week extension. Either way, if your benefit year did start before June 2nd, you should still apply, because the first thing EDD will do is determine whether or not you're eligible for any unemployment insurance benefits. So you should go ahead and apply to make sure that you'll be eligible to receive any benefits. It may take some time, but you should definitely apply for that.
Great. Okay, that makes sense. And what if I find myself in a position where I still haven't received my benefits?
Right.
Why
So
is it taking so long? And is there anything I can do?
Well, unfortunately, there's very limited things that an individual can do. The most common reasons we've seen for why an individual has not received their benefits are if there's an investigation, if the claim is pending, if they've been disqualified, or if they need to appeal. The investigation can happen for a variety of reasons. One, they may need to gather more information as to how much income you actually had. They may need to gather more information about your ID, more information about your employers or your past employers. And there's very limited acts that a person can take if their case is under investigation. You know, we encourage everyone to contact via the Ask EDD question, submit requests online. Phone calls continue to be a really bad idea because they will take a really long time to get back to you or to even answer your call. You might be on the phone all day. They're just really focused now on processing claims. But you'll just have to be patient. And unfortunately, that's something that's really hard to hear for individuals. And I feel terrible when I tell people this. We understand that people are waiting weeks and even months to have any income coming in through UI. And it is a desperate situation when people are unable to pay their rent. Unfortunately, there's really very little you can do beyond contacting EDD and asking them and providing them that additional information they may be requesting. Now, if you receive something saying that your claim is still pending and you've waited, let's say, about a month, you should reach out to our office. We have seen multiple situations where workers, for just due to a system error, where their claims have been pending for weeks upon weeks. And we have had some success reaching out directly to EDD regarding this matter and asking for assistance in correcting this issue. A similar scenario has happened for people who receive notices that they're suddenly disqualified, despite having been found eligible and actually having received benefits. You may be disqualified if you were penalized in the past for having, for example, refused to return to work, or having lied about the reason for your termination, or having taken an overpayment of benefits and not having paid it back. But we have seen individuals who were completely eligible for unemployment, had no penalty weeks that they had to serve, but all of a sudden were informed they were disqualified. Again, you should contact an attorney ASAP in order to get an evaluation as to whether or not this is something that needs to be escalated beyond merely ask EDD. And finally, if you receive a denial for your benefits, don't give up hope. There are many situations where the investigator makes an incorrect decision. For example, we've had a lot of cases where workers who, due to reaching an agreement, a settlement agreement because of a workers' comp claim, where they agreed to resign from their job in order to settle the workers' comp case, EDD says that they voluntarily left their job. But that's not necessarily true, because under the law, if you reach a mutual agreement to separate from the employment, then you are still eligible for unemployment benefits. It's really important that if you think that EDD got your case wrong, that you submit an appeal and do that within 20 days. That is the time limit that you have. If you are more than 20 days, you'll have to show that there was good cause, that there was a reason why you were unable to appeal within 20 days. And that just makes it a little more difficult for you to win your appeal. So don't delay.
Great. That makes a lot of sense. Thank you. And what if my employer misclassified me and didn't report any wages to the Employment Development Department, to EDD, when I filed for unemployment? What should I do then?
Right. So this happens to a lot, and particularly we're seeing this with Lyft drivers, with Uber drivers, with other gig workers, gig app and gig economy workers, DoorDash, Grub, all of these delivery apps. All of these companies continue to misclassify their employees as independent contractors, despite the law now having been very clear for the past couple of years that these workers are actually, in fact, employees. And these companies have refused to provide any payroll information to EDD. So these workers receive benefits and say, a benefits award where they're granted unemployment insurance benefits, but then they're told, you know what, your award is actually $0. And that is a horrible thing to see, that you've waited all this time to get a determination. It took you a long time to apply, and now you're getting $0. There's a quick way to address this. Before you apply, if people are still waiting to apply, we encourage people, just put together a packet of all the proof you have, showing that you actually received pay. So whether you have a 1099, if you have a W-2, if you have other proof that you received income from a company, or received any money from a company as reimbursement for as wages of some sort or another. Put that all together and fax that or email that to EDD before you apply. If they've already sent you a notice saying, you know what, you get zero benefits because we have no wages in our system for you, go to the Contact Us tab on EDD's website, request the or select the question category, claim questions, question type, missing wages from claim, and then write up a good summary as to why there are no wage histories in their system, right? Inform them that you were misclassified. If you had an employer that paid you in cash, paid you part in cash and part in check, let them know that this is what happened. And then EDD will either, approve an increase or change their determination as to your amount of benefits, or they will offer or they will contact you to collect more information.
Great. Okay. And then I know there are a lot of folks who we're hearing from who unfortunately are not eligible for unemployment insurance, but are obviously still impacted by this devastating situation with the closures caused by COVID-19. So what about folks who are not eligible for unemployment insurance? Where can they turn?
So for those people that are independent contractors, that are self-employed, are business owners, they may not have a work history as detailed as others, right? If they hadn't earned more than $1,300 in the past, in their benefit year, in their base period year, excuse me, there's pandemic unemployment assistance. Now this again came through the federal law that took effect as of April 1st. And this law created this pandemic unemployment assistance program that provides similar to unemployment insurance benefits, to these types of individuals. Now, because this is a federal project, California's EDD had to create a whole separate system for this, and it took a really long time to get this off the ground. But these individuals, for the past, I believe, 3 or 4 weeks, have been able to apply for this benefit. And right now, EDD is simply paying $167 flat, regardless of how much you earned, plus the $600 that also came through the CARES Act, right? The same federal legislation that established the Pandemic Unemployment Assistance Program. So after July, EDD, once it's had more time to get everything together, will look at the person's pay history or their income history and calculate whether or not they should receive a higher benefit. They just decided on 167 just so that they could start processing these as quickly as possible. But these individuals, again, will be able to receive that amount, 167 plus the $600 from March through the end of June for each week under the additional pandemic unemployment compensation. And then after the end of June, they will then receive whatever the calculated amount is for their UI-like benefit. Now, there are a lot of other workers that simply are not eligible for unemployment or PUA. Particularly, these are undocumented workers that are not eligible for these benefits because the federal government requires employment authorization in order to receive them. Thankfully, there are various funds that exist that have been created to provide support to these workers, including the Governor's Disaster Relief Assistance for Immigrants, DRAI. This is a program that people should be calling several organizations throughout the state. If you go on CDSS's website, you will be able to get contact information. Here in LA, those individuals should be contacting Carecen, Chirla, and Asian Americans Advancing Justice. They're the 3 groups administering. These organizations are receiving thousands upon thousands of calls each day, so it may take some time. Funds are first come, first serve, and they will continue distributing them until, I believe, they will continue taking calls through the end of May. Additionally, various other organizations have come together to provide funds for our undocumented immigrant communities. The mayor has created a fund and support specifically for this, but that was exhausted fairly quickly. Various different worker centers that work with specific populations provide financial support. If you're a car wash worker, contact Clean. If you're a garment worker, contact the Garment Worker Center. If you're a restaurant worker, contact the Restaurant Opportunity Center. If you're a domestic worker, contact the California Domestic Workers Coalition. These are all groups that are putting together funds to support individuals that are unable to receive unemployment insurance.
Great. And let me just ask, one more time, because I just want to make sure I'm really clear. So if I find myself in any of the situations that you've just described, Sebastian, if I am, haven't received my benefits and I have questions about that, if I feel like I've been misclassified and my employer reported my wages as 0 to EDD, and if I find myself ineligible for unemployment insurance, whether I'm an independent contractor or a business owner, and even if I'm undocumented, can I contact the Tzedek Employment Rights Project clinic for a little help?
Any person that has any issue related to work is welcome to contact our clinic. We can't guarantee you that we'll be able to provide direct representation. We have limited resources available to us, but at the very least, we will be able to provide you with direct support, advice, and counsel, and direct support in the form of advice and counsel as to what you should do. We might be able to refer you to a law office that might be better resourced or prepared to handle your claim, or we might be able to help guide you through the process. We make determinations as to whether or not we can represent individuals based on a variety of factors, primarily being whether or not we have the capacity to take on the case. If we do have the capacity and you are eligible for our services, we will represent you. We are supporting people in appeals for unemployment insurance claims. We continue to file wage claims when workers have not been paid for their work, and we are here to support any individual that has a question about work.
Great, thank you.
So we shall open this up now for questions. Well, if there are no questions, I also invite the general public. Everyone is welcome to volunteer at Tzedek. We always can use any individuals that speak languages other than English. So if you are interested in volunteering, please visit our website, contact us. There are different ways that you can help, whether it's providing translation or providing helping out at our clinic. Please contact our organization to offer support and volunteering. Again, we are a nonprofit entity, so we do have limited resources. And we would like to thank everyone for your support and for continuing to provide any support to Tzedek. If you have any questions, again, I'm just going to go right back to our clinic information so that you all can contact us if you have any questions. I encourage everyone to check out our workers guide. It's available on our website. If you have any problems, you can also just contact our clinic at 323-939-0506, extension 415. And with that, I'd like to thank everyone for watching and for your time watching this webinar. I hope that it was useful. I see that there is a question. I believe the question says, I'm working a part-time job 20 hours a week, and I had a full-time job working 40 hours a week. But due to COVID-19, my cut hours to only 8 to 16 hours per week. Would I be able to receive unemployment? So, Angelica, thank you for your question. So if I'm understanding this question correctly, the person has a part-time job for 20 hours and used to have another job for 40 hours a week, but now only has a job that is 20 hours a week and one that is 8 to 16 hours a week. So this is a situation where you would have to there's a calculation that you need to run. And again, this is a question that we address directly in our workers guide. But there is a calculation that you need to run to figure out whether or not you're eligible for partial unemployment. And basically what you're going to do is you're going to figure out if you have received unemployment and look at what your weekly benefit is. If you don't have, if you have not received unemployment, the first thing that you're going to have to do is you are going to have to figure out what your weekly benefit is. Your weekly benefit can be calculated. There is a calculator on the EDD's website. And I'm going to just try to pull that up right now so I can share that. And let me share a new screen. So if you go to, if you just Google weekly benefit calculator EDD, it will help you run through, you choose your start date. You're going to have to enter in your quarterly amounts, the amount that you earned each quarter. If it's about the same each month, you can just, let's say you're earning, $1,000 a month. It will tell you that your weekly benefit is $116. So then the math that you have to run is you have to calculate, once you get your gross benefits for the week, you have to subtract either 25% or $25, whichever amount is higher. So if your weekly benefit was $200, you would subtract a quarter of that, $50, and you'd have $150. If the wages that you are earning are more than $150, you would not be eligible for that benefit. If it's less than that, then you would be eligible. So, Angelica, you're going to have to do a little bit of math and figure out if the total amount of money that you're earning is going to be more or less than that weekly benefit. So again, thank you all for your time. I hope this was useful. Again, thank you to the Los Angeles Public Library. I know that they have posted now our guide. They have also posted the calculator. If you have any questions, again, I encourage you all to reach out to our clinic, 323-939-0506, extension 415. Joe, thank you for joining me on this conversation. And we look forward to seeing everyone else later. We will be doing the same presentation on Thursday afternoon in Spanish. Please let your family members and community members know that we will be doing this presentation. Thank you very much. And with that, we will be logging off. Bye.